So welcome. My name is Kara. I work at the California Civil Rights Department. I again want to thank the Department of Real Estate for partnering with us on this training series. The first one last week was great. We got a ton of great questions, and so I'm really excited to jump into part two. Just a little bit of info before we start. I think Taylor's already told you this, but please just put all questions in the Q&A, not the chat. It just helps us keep track of them. We're going to do our best to get to everyone, but we had about 800 people registered for this webinar, and there's about 400 of you on already. So, we're going to do our best to get to as many as we can. Clearly, we're not going to get to all of them. Closed captioning is available. You can enable it by clicking the button at the bottom of your screen. We're not providing a copy of the presentation, but we are going to post a recording, which will send a link to all the participants. We're going to give you a link to an evaluation form, so please fill it out. It helps make these trainings better. And, we're not providing any type of continuing education credit for attending the webinar, but we're glad that you're here. All right, go to next slide. So here's our agenda. We're going to have a very quick just about what DRE and CRD do. We're going to talk about reasonable modifications, source of income discrimination, fair housing protections for people with criminal histories. We're going to have some resources, and then we'll have time for questions. So I'm going to pass this over to my colleagues over at DRE just to give a little information about them.
Thank you, Kara. My name is Steve Lerner. I'm the Assistant Commissioner for Legal Affairs. That's a fancy title for Chief Counsel. I oversee the department's legal program, the attorneys that handle license discipline, as well as providing legal advice to the commissioner, the executive team, and others in the department. Chika, would you like to introduce yourself, or would you like to have me do that?
Oh, thank you, Steve. I'm Chika Sundquist. I'm the Assistant Commissioner for the Enforcement Division for the Department of Real Estate.
And Chika and I work hand in hand on a lot of disciplinary matters involving licensees at the Department of Real Estate. And we also work close with our sister agency, what is now the Civil Rights Department. You may remember in years past, it was called the Department of Fair Employment and Housing. It recently got a name change, but we're glad to partner with them on today's presentation. But I just want to go through some quick steps. For those of you that attended last week's, I'm going to go through some stuff that you may have heard before. For those of you that are new, this may be new stuff for you. But in either event, just quickly, today's presentation is for informational purposes only. We are not trying to create any new rights, whether they be substantive policy or procedural rights. We are not giving legal advice. Several of us are attorneys, and we don't want to create an attorney-client relationship. But we are here for informational purposes and to try and offer you as much guidance as we can on subjects of interest to both of us, or all of us, I should say. So with that, Kara, if you can flip the slide. And just a quick overview. The Department of Real Estate was created about 100 years ago, a little more than 100 years ago. Our primary focus is consumer protection, California consumers in the real estate market. And we do that mostly through licensure, enforcement, regulation, and education. And those are our essentially four big tools that we rely on, but we really look to do more with education to educate people, and that's what today's presentation is about. To the extent that education doesn't get the message across and we still have problems, then we have other tools to rely on by relying on enforcement or regulation. And you'll hear this throughout the presentation, but both the websites of the Civil Rights Department and the Department of Real Estate have a lot of resources that are available to you. So if you have questions that are not answered today, or other questions that come up after today, please take some time and look at our respective websites, because there is plenty of information on there that will help you do a better job in your given fields. But with that, Kara, if you can flip to the next slide.
I think that's
that may be it. So right. Thank you very much. Kara, your turn.
All right, thank you. And thanks again for your partnership, everyone at DRE. Similar to what Stephen said, this is for informational purposes only, no policy rights, no legal advice. The opinions expressed by other presenters don't necessarily reflect the opinions of CRD, and this is the most recent guidance as of the date of the training. Things always change. The law is continually changing. Just really quick, we're the Civil Rights Department, we're California's civil rights agency, and we have a gigantic job of protecting people in California from unlawful discrimination and enforcing many of our civil rights laws. And here are some things that we do. I think many of you may be already familiar with what we do. We investigate complaints, which is a big part of what we do. We do mediation, we prosecute cases under the law, we issue regulations to implement the Fair Employment and Housing Act and other statutes. We collect pay data and education and outreach, which is what we're doing right now. This is just some info on accessibility of our services for people with disabilities. We have a process. This is that information. And also, we're able to provide services in many different languages. And here's some information on how to access those services. So let's jump in. We're going to start with reasonable modifications. And let's, and again, I'm going to tell folks, if you have questions, throw them in the Q&A, and we'll do our best to get to them. And Stephen and Chika are going to probably answer a few of those questions too as this goes on. So a reasonable modification is a physical change to housing. And we're talking physical change. It's not, we're not talking about what we talked about last week, which was a reasonable accommodation, which is kind of a change to a rule or a policy. This is an actual construction physical change. And it's to ensure people with disabilities to have an equal opportunity to use and enjoy housing. Failure to allow a reasonable modification is considered to be housing discrimination. And here's some quick examples of modifications. Installing grab bars is a biggie, installing a wheelchair ramp, doorbells that flash when a person who's deaf. So if someone rings the doorbell, it flashes so they know someone's there. Widening a doorway, lowering cabinets. Here's some photos. And so I'm hoping to make this interactive. So this is our first question, and I encourage you all to participate. Is it always the housing provider's responsibility to pay for reasonable modifications? So I'm going to give folks a little bit of time. And thank you for participating. We've got hundreds of folks putting their answers in here, which I really appreciate. Makes it a lot more interesting, I think, than just hearing me talk. So, okay, I'm going to end the poll. So we have about 37% of folks said yes, and 63% of folks said no. What's the answer? No. It is not always the housing provider's responsibility to pay for a reasonable modification. And again, these are physical changes. So when is the housing provider required to pay for a modification? So if a property is subsidized by the federal government or state government, under many scenarios, that means that they would have to pay for the modification. This is usually with affordable housing or government subsidized housing, because you'd be subject to laws to require you to do so. Also, if a modification is needed because the housing provider just didn't maintain the property, an easy example is, if you live in a building, if someone lives in a building with an elevator and they need the elevator to access their unit, and the elevator has been broken for a really long time, asking for them to fix the elevator would require the housing provider to pay, because they're supposed to have the elevator in good working order. So that would be up to the housing provider. Also, the building codes they change a lot, but basically there are certain accessible features that are often required when a property is built. And if it was required and it wasn't included, then, if someone asked for it later on, that still would be the housing provider's responsibility. And if a housing provider is required to make those, to pay for reasonable modifications, then usually, the process is handled similarly to the reasonable accommodations process that we talked about last week. So denial of a reasonable modification. So when can a housing provider deny a reasonable modification? If the requester isn't disabled, or they can't demonstrate that there's a relationship between, allowing for them to make a modification and a disability related reason to make their unit or the common area accessible. If the requester refuses to pay for it, so under most circumstances, unless we're talking about the scenarios I just talked about, the requester, the tenant, is responsible to pay for the modification. So, excuse me, I am in the midst of a cold. If the requester refused to pay for it, then it could be denied because it's not the housing provider's responsibility to pay for it. If the requester won't tell, the housing provider kind of what they plan to do or show them what they plan to do, and it is the housing provider's property, they do have a right to see kind of what's going to happen, make sure that there's permits, or, if the requester refuses to restore the changes, and this is only in regards to changes that are made to the tenant's unit. If, for example, the tenant pays for a wheelchair ramp to help them to go in and out, and that's in the common area, then they are actually not required to restore it back. Or if the housing provider is required to pay for the accommodation or the modification, and it's too expensive, it's an undue financial burden, and again, like a reasonable accommodation, we're really looking at the individual circumstances, how many resources does the housing provider have? Are they a tiny landlord? Are they a large landlord? Usually if they're government subsidized, they're going to be much larger housing provider, and if there's any alternatives. So let's do some hypos, make this a little more interesting. So Miko has physical disabilities that make it difficult and painful to navigate stairs. The pool at Miko's apartment complex has a pool lift that Miko has used consistently over the years when using the pool. Last year, the pool lift broke down. Management told Miko they don't have the funds to pay for it, and they are not the recipient of state or federal funds. So management tells Miko, we'll permit you to pay for it, but we're not going to pay for it to be fixed. Have they violated the law? And the answer is yes, they have. And, even though they're not receiving funding from the federal government or state funding, they're still required to pay for the repair because it was an accessible feature that existed when Miko moved in. So, it already existed. So it's a maintenance issue at this point. The housing provider had it, failed to maintain it. So they are responsible for the repairs. All right. So that was reasonable modifications in a nutshell. I could definitely have done a training for 2 hours on just that area. So I just want to tell you that, we're just really kind of glossing over the main issues with a lot of the fair housing issues that we're going to talk about today, but that was just some basic information. So now we're going to talk about source of income discrimination. What is the source of income? It's basically, how a person pays their rent, where their income comes from. Is it a benefit? Are they getting SSI? Is it housing assistance like Section 8? And the law basically means that a property manager, housing provider can't discriminate against a tenant based on how they're going to pay for their rent. You can ask where someone's income comes from, you just can't use where that comes from as a source of discrimination. So let's do some hypos to kind of dig into this a little bit. So in this hypo, Bashir has a Section 8 voucher. Housing provider's like, I have no problem taking Section 8, but I'm not filling out all this paperwork because it's a pain in the butt. So the housing provider, Ariel, is like, I'm not filling it out, but I will accept your Section 8 voucher. So let's do a poll. And I'm going to give you guys a little bit of time while I take some water. All right, I'm going to end the poll. Most of you, 88% of you said yes. 12% of you said no. And the answer is yes, she did. You know, even though Ariel in this scenario said she had no problem taking Section 8, Section 8 discrimination includes, you know, not doing the procedures or filling out the paperwork that you would need to do in order to accept it. Another example is source of income discrimination. You have a tenant that doesn't have Section 8 and then they finally get off that wait list and you refuse to, you know, renew the lease. That's another form. Let's see, refusing to renew a lease, imposing, so if an insurance company has different requirements, charges more if you rent to people with Section 8, that would also be considered source of income discrimination. There are many more. Let's do another hypothetical. This is Sasha. She's applying to rent a 1-bedroom unit. She's using a combination of a local housing subsidy and her monthly public benefits to pay rent. She received notice that her application has been rejected because 1, she can't provide 3 months of pay stubs from employment, and 2, her credit score is just too low. So did the housing provider violate for housing law for rejecting her because of the lack of pay stubs? So under the source of income discrimination laws, you know, requiring somebody to provide pay stubs would be source of income discrimination because people have other sources of income that don't involve, you know, having active employment. Like here, not only does Sasha have, she's receiving public benefits, she also has some tenant-based assistance, local tenant subsidies. So, you know, it is a pretty standard practice generally for housing providers to say, hey, I want to see 3 months of pay stubs, but that can't be a flat-out requirement. If somebody has a source of income that's something other than employment, that would be considered source of income discrimination. What about her credit score? So housing providers are allowed to screen tenants for other lawful reasons. This means a credits history. So, you know, just because, you know, Sasha here has a government subsidy for housing and public benefits doesn't mean that she has to be admitted. If she has a credit score that's lower than what the housing provider normally requires for admission, then the housing provider can deny her application. You just have to make sure that you're using the same standards for everybody applying, no matter if they have employment or public benefits or anything. So also, you know, what their level of income is. So, you know, not where it's coming from, but do they make the requisite amount of money that you normally would screen for? You can look at rental history. We're going to talk a bit more about conviction history later on. But again, you just have to make sure that you're using the same criteria for everyone. Here's another hypothetical. This is Octavio. He has a Section 8 voucher and he wants to live in a 2-bedroom with his partner and children. The rent for the unit is $2,500 and Octavio's portion of the rent with the Section 8 voucher would be $450 because he makes about $1,600 a month as a farm worker. And, you know, just a little aside for Section 8, how it works is that, you know, Section 8 pays, they make it so you're paying up to 30%, sometimes a little more of your income in rent, and then they make up the difference. So here, Octavio's portion of the rent is $450. The landlord denies Octavio's application because she has a policy that applicants must make 3 times the monthly rent to qualify. And she's saying you must make, 2,500 times 3, which would be 7,500. And did sorry guys, did the landlord violate fair housing law? And the answer is yes. If a housing provider requires a minimum income that's a multiple of the monthly rent, the housing provider should only look at what the tenant's portion is. So here, Octavio's monthly rent, it was about $450 a month, and looking at 3 times what that would be looking to see if he makes 3 times his monthly portion of the rent. A housing provider can't use the full cost of the rent and require a tenant with housing assistance to make 3 times that actual full monthly rent, because it would essentially be a way to screen out everybody with government assisted housing assistance. And this is actually part of source of income discrimination, but it's also a separate law in the state of California. So Rabia has a Section 8 voucher, and she applies to live in a 3-bedroom home with a monthly rent of $3,200. The landlord looks up the payment standard and sees that it is capped at $3,000 a month. She rejects Rabia's application, telling her, hey, you're going higher than the payment standard, so we're not taking you. And what I mean by the payment standard is, for each housing authority across the country, each county in California, and some counties have local housing authorities, they set kind of their max amount that they would pay, they would allow a tenant to rent for. So, where I live in Oakland, I believe the payment standard for a 1-bedroom is about $3,000. And so in this hypothetical, Rabia's the landlord is saying, hey, the housing provider's payment standard says that you can only, the rent can only be up to $3,000, but our rent is $3,200. So did the housing provider violate fair housing law? And the answer is yes. The payment standard, the housing provider, it's really not, the housing provider can definitely check to see if you're receiving assistance and if it'll cover the rent, but payment standards on their own, the maximums aren't actually the only factor. So, housing authorities and the law actually allow people to pay a little bit more than 30%. So Rabia in this case could make up the difference between $3,000 and $3,200. There's other ways that Rabia might actually get more assistance from the housing authority, but it's really between her and the housing authority. If after you process the application, you're not, you can find out from the housing authority, that she'll be able to cover the full amount, that's fine. But, housing providers shouldn't be, looking at the Section 8 requirements and, trying to screen people out based on those. And, we do some fair housing testing, and we found that this is a way that some housing providers are trying to kind of get around the source of income protections. So we're going to do another poll. This is Lynn. Lynn puts in an application to rent an apartment from Sarah. Lynn mentions that she'll be using the house to run a small licensed childcare, and Sarah denies her application, stating that the other tenants would not be happy about the noise from the children. So did Sarah violate fair housing law? And I'm gonna launch this and give you guys a minute to answer. Okay, I'm gonna end the poll. This was a fun one. We had 69% say yes and 31% say no. And the answer is yes. not only is this, a source of income discrimination situation because that's where her income is coming from, but, a housing provider might say, hey, but you're using my property to run a business. I don't want that. However, in California, providing childcare in your home is actually protected, and the law states that it's a residential use of the property and is protected. And here is the health and safety code. And again, there's a lot more information than this. I'm going to provide resources at the end. We have a fact sheet on childcare protections under housing law that can provide you more information. And here's a little bit more. Again, you can't evict, raise the rent, charge people more because they're gonna run a licensed childcare home. But we are talking about licensed childcare homes. That means that a housing or a childcare provider does have to be licensed under the state of California. There's small child family care homes for up to 6 kids, and large child care home licenses for up to 12 kids. But we are talking just license. If someone's just running something a little more informally, that is different. They also apply as an aside, just to, if you're purchasing or renting a home, if you are renting or own a home that's a condominium or, is subject to a homeowners association. And even for realtors and mortgage lenders. So, if a real estate agent is showing properties and they're concerned because the person says, hey, I want to buy this house and I'm going to run a licensed childcare, and the realtor is like, I'm not going to show you this house in this area because these people won't like that you're running a childcare. That would also violate the law. And housing providers can't require liability insurance, and insurance companies. So if your own homeowner's insurance or insurance company says, hey, I won't insure you if someone's running a childcare, that actually violates fair housing law. And it can't be a reason to deny somebody's application. But that insurance company would be violating fair housing law. And local governments can't place additional restrictions on childcare homes because it's considered to be a residential use of the property. All right, so again, I could do a 3-day training on source of income, but I'm just trying to give you guys some general information, and we're going to move on to some fair housing protections for people with criminal histories. Another, the same caveat as I just said, this is an area where I could, go on and on for several trainings, but I'm just going to give you kind of the basics. So what do we mean by criminal history information? Any record that identifies somebody as having contact with law enforcement. It includes arrests and how they're resolved. So are they dismissed? Did someone get convicted? Information that someone's been charged with a felony. Felonies can result in more than 1 year in prison. I'm just giving you information on kind of what, so just as an aside for criminal history, felonies only account for about 26% of arrests in California. And if you go to like serious violent offenses like homicide, rape, kidnapping, it's like a small fraction. Most people who are arrested are charged with misdemeanors. It's to keep that in mind. Information that shows, criminal history can also be, just info that someone was questioned or taken into custody. There's a lot of records that follow people. All right. Let's do a hypo, make this a little more interesting. All right. So, in this hypo, James applies to live in an apartment, and after receiving his application, the housing provider runs a criminal history check. The criminal history states that James has been arrested several times for sexual assault. The housing provider denies his application. Was this a lawful denial? And I'm going to give folks a few minutes to answer. All right. All right, I'm going to end the poll. All right, so we had about 63% that said yes, and about 30-some% that said no. The housing provider, was this a lawful denial? So the answer is actually yes. I'm so sorry, I put the circle in the wrong place, but yes, housing providers can't consider information that criminal history information that is an arrest. Arrests by themselves are actually not considered to be a lawful way to screen somebody for housing with criminal history. So here, even though the arrest for sexual assault, they sound very intense and, scary to some folks, these are just arrests. They are not convictions, and they're not considered to be proof of somebody's culpability or, whether or not they committed this act, because they are just arrests. So this was a lawful denial despite me putting the circle in the wrong place. So my apologies. So why are arrests excluded from consideration? So there's many reasons, but this is, I think, really helpful. In 2016, HUD, or the Department of Housing and Urban Development, put out some guidance, but basically says, the fact that someone's been arrested doesn't have very much probative value in showing that they've done something, because it hasn't been adjudicated. Nobody's looked at, the facts of the case. It's just, that someone's suspected of engaging in a crime. And the law is pretty clear that, they don't, arrest records on their own don't constitute proof. So they can't be considered when you're considering a tenant for admission to a property. And, for that reason, a provider who denies housing to persons on the basis of arrest can't prove that the exclusion actually assists in protecting the resident's safety or property, because, here you don't even, if someone's been arrested, it does not mean that they engaged in that activity. So there's really no probative value of considering arrests. But there is criminal history information that so there is other criminal history information that housing providers can't consider. So again, we just talked about arrests, but if an arrest led to a conviction, so, James was convicted of sexual assault after those arrests, then that could be considered. Other information you can't consider, just showing somebody's been taken into custody, questioned. Again, you're just suspecting something, you're getting information, you're not actually just determining whether somebody, did something wrong. Infractions, parking, or speeding tickets. I can't imagine most housing providers would care if someone had a speeding ticket, but it's still on there. If somebody went to like a diversion program, so oftentimes people are, especially with like drug offenses or arrests that are due to somebody's mental health conditions, there are programs where, if you get treatment, then, it doesn't turn into a conviction, so you can't consider those. Let's see. And, things that have been sealed or dismissed. There's so many issues with criminal history records in the United States. I believe they've found that more than 1/3 of criminal history information in background checks is incorrect, or there's mistakes. So even if things have been sealed or dismissed on people's records, oftentimes, even though they're supposed to be, they're still there. So you still can't consider them. If somebody was prosecuted in the juvenile justice system, again, you can't consider that as well. And blanket bans. So I think this is what comes up the most with housing providers, but basically, having a blanket ban, saying, hey, I won't take anybody with felonies, that is unlawful. you know, I won't take anybody with any type of violent offenses on their record, convictions, that's considered to be a violation of the law. And the reason for this is, you know, blanket bans don't allow for any type of analysis of whether a conviction is directly related to somebody's ability to be a good tenant. And I'm going to go further into that, what I mean by that. So what I mean by that is when housing providers are screening people with conviction histories, and we're talking about, you know, the convictions, not arrests or all that other information, housing providers should only deny people with criminal histories if the criminal history is directly related to their ability to be a good tenant, for safety, you know, their ability to, you know, that there's not like a big risk to property and people, to other tenants. You know, and our regulations interpreting the Fair Employment and Housing Act, they say a directly related conviction is one that has a direct and specific negative bearing on a substantial, legitimate, and non-discriminatory interest. What does that mean? What it means is, again, it has to be directly related. And I'm going to go through a bunch of examples to kind of tease out what I mean by this, because lawyers and people making laws, they often write things like this. And I think people are often like, what do you mean by that? Because it's just a lot of words. But what do we actually mean by that? And those regulations do go on to say, you know, in determining whether a criminal conviction is directly related, you know, housing providers should consider things like the nature and severity of the crime and the amount of time that's passed since the conviction. So what does this mean in real life? I'm going to do a poll. So let's go back. Hold on. Much better. Okay. Sorry, technical difficulty. Abby is applying for an apartment, and the application includes a criminal background check, and it shows that Abby was convicted of residential arson 1 year ago. The housing provider denies her application, saying that having a tenant with a conviction for residential arson would be a big risk. And does that violate fair housing law? Go ahead and answer. And was this a lawful denial, yes or no? All right, I'm going to end the poll. So we're at about 68 says, yes, this was a lawful denial, and 32% that say no. And the answer is yes, or probably yes, because again, it's really hard to, you know, but yes, I think under the circumstances, this housing provider has a very good argument that Abby's recent conviction for residential arson is directly related. It's been a year since this happened, so not very long. And the crime was incredibly serious. The person, you know, burned down a residential property. So under this hypothetical, it's likely the housing provider would have a very good argument that this is a directly related conviction. All right, Luann. Luann applies to rent an apartment, and she agrees to a background check, which shows that she was convicted of drunk driving 10 years ago. The apartment manager tells her she can't have an apartment due to her conviction history. And what do we think about this one? I'm going to launch it. Do you think this was a lawful denial, yes or no? And I'm going to end this poll, but most of you answered no, and I think that is correct. The housing provider would likely have a very difficult argument this is drug related. You know, it's drunk driving. It's not really, doesn't really have much of a relationship to being a tenant, and it's been 10 years. So under those circumstances, it's, you know, a housing provider would have a very difficult time arguing that, you know, denying somebody for this conviction history would be directly related to their ability to be a good tenant. So, all right, let's make it a little stickier. This is Emil. Emil's criminal background is checked as part of an apartment application. He receives an email from the complex that he's been denied because his name appears on the sex offender registry. The property adds that they would never rent to anyone on the registry. Was this a lawful denial? So let's go back to Emil. All right, I'm gonna end the poll. We are at almost a dead heat of 50-50, which makes this much more interesting. And I think a good reason why this hypothetical is important. Was this a lawful denial? No, it was not. I think this is going to surprise many people. Even with the sex offender registry, the housing provider can't have a blanket ban. They can't say, I will never rent to somebody with this type of conviction, because it doesn't allow for an analysis of whether this is directly related to their ability to be a good tenant. So now what you're saying, I'm thinking in your head is, let me take a sip. What do you mean by this? This person's on the sex offender registry. Of course, this is like a risk to health or safety of other tenants. So let's dig into this a little bit. So something to know about the California Sex Offense Registry is in California, it's one of the few states until very recently that no matter what your offense was, you're on the registry, and it's not like in other states, and then now in California very recently, the registry is tiered. So, for really lower level offenses, you only have to register for a certain amount of time. For really high level offenses, things like rape, child sex trafficking, you'd have to be out there for a lifetime. In California, no matter what your offense was that got you on the registry, you're just on the registry. This means that if you are arrested for indecent exposure, I've had clients that were arrested for urinating in public, and this is a large percentage of people on the registry. They would be considered to have to be registered on the sex offense registry. So also it could be things like, statutory rape. So say you were 20 and, you engaged in sex with somebody who was 17, and they, you would also have to register as a sex offender. So knowing that somebody's on the registry itself, by itself is not enough information to make that determination. And, as a result, there's California Sex Offender Registry. There's a significant number of low-level offenders, people who were convicted decades ago for urinating in public, for indecent exposure, and who'd present really little to no risk to the communities they live in. As of this year, California's registry is now tiered, but it did not actually go back and change anything. So they didn't actually go and change it around and say, oh, hey, you were convicted 20 years ago of indecent exposure, so we're going to put you as a tier 1, which means you only have to register for a certain amount of time. People have to apply individually. So most people are just still on this registry with very little additional information. So, and the reason I use this example is it just really shows that you do have to consider kind of the nature and circumstances involving the conviction and the amount of time that's passed. I'm not going to tell you that if you have somebody that applies that has a lifetime registration for rape and child sex trafficking, what you should do there. I think, but generally, you should consider whether this person's conviction is directly related. And if people especially for these lower level offenses were not on a sex offender registry and you were just looking at conviction history, it's unlikely that you would actually see it as something that would be directly related, especially if these offenses had happened a long time ago. So that's why I use this example. And with that, I'm just going to present a few resources. We have a ton of information on our website. So does DRE. I highly recommend their landlord tenant guide. It's really long. It has a lot of really good information. And then this is we have fact sheets on disability discrimination, childcare, providers, criminal history, source of income. Again, I was only able to kind of scratch the surface. You know, this training was really meant to kind of dig into the hairier issues with fair housing, but obviously I couldn't get into everything. And here's some info for us and questions. And we have 62 already in the Q&A. And I'm going to ask Stephen and Chica to help me out here and ask some questions. And I really, really appreciate it.
Kara, wonderful job. One of the questions that came up is can someone basically incorporate the cost of making a modification in rent, like charge extra rent or take portion of the security deposit to pay for the modification?
If the housing provider is required to pay for it, then no. If the tenant's required to pay for it and the housing provider's like, hey, you know, you need this wheelchair ramp, it's going to cost $1,000, so I'll go ahead and pay it and take $100, you know, charge you an extra $100 a month in rent, then, you know, it's between the tenant and the housing provider. I don't see that being an issue. But, you know, if the housing provider is required to do it, then no, because that would be making them pay for a modification that they're not required to pay for.
And what about for a licensed childcare? Are landlords permitted to ask for the childcare license?
They could ask for proof of the license. I think there's a way that you can also look the person up. It's on the Department of Social Services website. And I believe there is a way to look it up, but I mean, the protections only do apply to licensed family childcare homes. So under those circumstances, you know, I think it would be reasonable for the housing provider to say, hey, I just want to make sure you're licensed. That would be fine.
There are a few questions related to the housing vouchers not getting to the, getting to the point where it pays the full rent amount. I don't know if there's anything you can help on there, that topic.
I probably would need a little more info on the question. So
okay. Yeah, like being able to deny somebody where their housing voucher doesn't quite meet the rent that they're being asked for.
Yeah, I can go into a little more detail on that. So just to remind folks, the payment standard that's set by the local housing authority is the amount that the housing authority generally will only allow someone to rent a property up to that amount. So in Oakland, I think it's $3,000 for a 1-bedroom. And in our hypothetical, the payment standard was $3,000 and the rent was $3,200. So the housing provider was like, hey, you don't meet the payment standard. This exceeds the payment standard, so I'm going to deny you. And so one, it's considered source of income discrimination because it's really between the tenant and the housing authority. And the reason I wanted to include this hypothetical is, and I apologize, this cold is killing me. The reason I wanted to include this hypothetical is there are many scenarios in which the housing authority will actually pay more than, allow somebody to rent a property for more than the payment standard. Tenants can actually make up the difference up to a certain amount. So here, you know, Rabia, I believe her name was Rabia, was the person who had a voucher up to $3,000, but the rent was $3,200. Rabia would be permitted to pay up to 40% of her income in rent, which means she could make up the difference between $3,000 and $3,200. You know, the housing authority is set Section 8 rents at 30% of someone's income, but again, the tenant can choose to pay more. If somebody has a disability and they have a disability related reason to need a specific unit, maybe it's close to where they need services, maybe it's one of the few accessible units, the housing authority could grant an exception to the payment standard, which means that they could pay more. there's several different scenarios. So, you know, looking at just the payment standard as a housing provider doesn't give you enough information to determine whether somebody would qualify to be able to rent that unit. And it's honestly, it's a scenario that is between that tenant and the housing authority. So, you know, landlords, you know, looking at that amount and just, you know, saying, you know, my analysis of the Section 8 program is you wouldn't qualify is unlawful. It's, you know, and it's been what we're seeing in our testing program is we're seeing it as a way that housing authorities or housing providers are trying to kind of get around the source of income. So what I would say as a housing provider is, you know, you can say, hey, you know, I do know this, you know, what's this, are you going to be able to rent? But you know, I'm seeing this difference between this, you know, what's going on with this. But denying somebody based on your own analysis of the Section 8 program is unlawful, and you just shouldn't engage in it. So hopefully that's helpful. And I see folks are raising hands. We unfortunately aren't going to be able to unmute people and let them ask questions. But I'm happy to answer them. So do you guys see any other ones? I mean, there's a lot. I know there's a lot to look through.
There are a lot of very specific ones. We're trying to kind
Yeah.
of bundle them together.
I'm seeing a lot of questions around the sex offense registry, and I knew that there would be. You know, the thing I want to reiterate is that, you know, you can consider directly related conviction history, but the fact that somebody's on the sex offense registry by itself does not give you enough information without knowing more about the nature and circumstances to deny somebody. And, you know, like I was saying, you know, if somebody, you know, is on the registry, it doesn't mean that they're a violent, you know, child molester. It means that they're on the sex offense registry, and they could have been convicted of a variety of crimes, from indecent exposure to very, very serious crimes. So you have to dig further into it than that. It doesn't mean that you have to, you know, I'm not going to tell you what you need to do, but it doesn't mean that you automatically can't consider whether somebody was convicted of molesting a child in your consideration of whether to rent somebody. That's not what we're saying. We're saying that you need to know more information to be able to do that analysis. So,
Tara, would it be a violation of fair housing law if someone was a tenant and during their tenancy they were convicted of a felony and the landlord tried to evict them?
I mean, if they were convicted of a felony, it's likely that they're not going to be able to live there anyway. But if, you know, no, I mean, I think you'd really want to look at, you know, again, the nature and circumstances. You know, it's likely if someone was convicted of a felony and it was for something, you know, related to your concerns that there's a risk to health and safety of the other people in the property, that you would be okay in being like, hey, I don't feel comfortable with this. But it would really depend on, you know, I'm not a criminal defense or criminal attorney, so I'm trying to think of felonies that, you know, wouldn't be considered, you know, aren't violent, but again, it just really depends on the nature and circumstances.
Is the childcare the only protected business type, or are there others?
One really quick, I want to go back to what it just said. In California, there are just causes for eviction. So, you know, you are going to want to follow those. And in considering, so if somebody, you know, engages in, you know, felony activity on your property, it's likely that that's going to be considered a just cause for eviction. So I want to throw that in there too. Other businesses that are protected, not that I know of, you know, it's not an area that I've dug super far into, but for purposes of this, what I do know is the childcare, licensed childcares. Let's see. My goodness, 81 questions. Thank you so much for And all types of housing need to abide by the childcare protections. That means if it's an HOA, they can't deny somebody because they're operating a childcare. It's considered to be a residential use of the property. All right. You guys see anything else? There's so many.
There's too many and they're all very, very fact specific. So it's hard
Yeah,
to throw
that's
them out
what's,
for a group audience.
yeah, it's challenging.
But we are also very close to the end of our hour.
Yeah. So why don't we'll end it here. And, you know, again, I just appreciate everybody in attending. You know, I wish we could answer everybody's individual questions. You know, we can't give legal advice, but, you know, in general, you know, I know that there's folks have a lot more questions than that. What I would do is encourage you to sign up for our training listserv, because we often have trainings. You know, we'll do an hour on just source of income or an hour just on criminal history. Look at both DRE and CRD's resources that we have, and, you know, just continue to engage in these trainings. And I very much appreciate everybody that attended, and you were a great group and you were really engaged, and it was great to have you. I don't know if you guys have anything else you want to say, Stephen or Chica.
Wonderful job, Kara, and thank you for partnering with us. And thank you
Thank you
everyone for
too.
attending.
We love partnering with you guys. So thank you so much, everyone. Have a good rest of your day.